You've just been appointed as guardian, conservator, or perhaps both. Now what do? Is it time for a breather? Not quite yet. There are a couple of immediate filings that are due within the first 90 days. Within 14 days of your appointment, you'll need to prepare and file a notice of rights. We call it the 14-day notice because that's when it should be filed and served to the individual. Within 90 days, you'll prepare and file a care plan. You get a little break until the first annual report is due. Here's a sample snip from an order appointing guardian and conservator. They were appointed on December 27th, 2024. It's not exactly in sequential order, but towards the end you'll show the 90-day due date for inventory and plan. It doesn't mention the 14-day notice, so hopefully you found this video. What is this 14-day notice? First off, it reminds you to send a copy of the signed order appointing guardian and conservator to the individual. Second, it gives the individual notice of a list of rights they have, such as being able to request a change or end of the guardianship or conservatorship, hiring an attorney, being involved in decision-making, socializing with who they want to socialize with, receiving court filings, even filing a complaint, among other things. Just another plug to always check the forms website online frequently for updated forms. And I'm also talking to you attorneys. For example, in 2023, we had a 14-day notice and we had a 30-day notice. But a year later, they condensed this into a single form and then they advanced it to this 14-day deadline. So don't just recycle old forms you may have seen. Laws change and the forms website fortunately reflect those amendments. What's due in 90 days? First off, let's not wait the full 90 days. Let's target something more like 60 days. That should give you enough time to get a sense of what's going on and prepare this filing. There's a personal care portion of the plan, like housing and medical, and then there's a financial section where you list the assets, debts, income, and budget of the individual. If bond and blocking was not determined up front, this is the place to do it. See my other video on bond and blocking. The 14-day notice is just filed and served. This care plan, inventory, and bond requires a signed order. So you'll need a proposed order and a way to get this order before the court. Do you need an attorney to prepare these filings? It's not a requirement. It's not particularly difficult, but there is a learning curve and practices change. Forms, procedures, how to file, how to note a hearing. This will depend on the county you're working in and what constraints that court is potentially facing. Here's a snip from the state website with some of the relevant forms. Again, always check the website for the most up-to-date forms. You'll also need to check the county database for local forms. These are needed to set a hearing before the judge or commissioner. Again, there are some limited instructions on the website. Well, that's a high-level overview of what to do in your first 90 days. Thank you for watching this presentation, and as per usual, consult with an attorney in your jurisdiction for advice specific to your situation. Let us know if we can help.